I'm Mary Henderson, and my colleague Annette Hiatt and I are really happy to be with you all today. Appreciate you making the time on an afternoon, and we're here to speak with you about heir property, which you also might see referred to as heirs property with or without the apostrophe. It's all valid. Just regional differences on how which phraseology we use. Annette and I work at the Land Loss Prevention Project, which is in North Carolina, and we're both senior staff attorneys there. And I think we've both been there for pushing 20 years-ish. So a lot of familiar faces here. And for those who, we haven't met before, we're happy to meet you because we're happy to be part of the DBAN network and excited about their work. We're going to, as lawyers, give our disclaimer slide, which is that the information we're sharing is certainly going to touch on some legal issues, but it's not intended as legal advice to you or to the farmers that you work with. Um, because we are a North Carolina-based organization, a fair amount of our experience is going to be based in North Carolina law. And the law of property, of real property of land, tends to be pretty state-based. So we will be sharing our knowledge, and you should always have the caveat in your mind that the situation could be slightly different depending what state you're in. Okay. And as Mary Oxendine said, please feel free to drop, questions in the chat, and I told her to feel free to interrupt us with questions. We definitely want it to be a back and forth and a conversation with you all today. We're not a huge group, so if there are particular concerns folks want to talk about, we're really happy to do that. Um, Again, Annette and I have been with Land Loss for a while. We will start today just with giving a little overview of our organization, and then we're going to talk about some of the basics of real property and land and what it is to own land, both in legal terms and, in some of those more intangible ways. The main focus is going to be on heir property, both what it is, how it has come to exist, how much of it there is, what it means to own heir property, and what are the particular, challenges that come with it, and how advocates can assist with some of those challenges. And then we are going to have some scenarios to look at in terms of what to look for, and um, some common misunderstandings that we'll try to share some information about. And then we will move on to options for resolving some of the challenges of air property and access to programs. And then finally, we have at the end a list of service providers, legal and technical assistance. We tried to make it as broad as we could since, this is a national group we're talking with. And again, feel free to put questions in the chat. And then in terms of what Land Loss does, so we were founded in the 1980s in response to the steep decline in Black farmers in the Southeast and in North Carolina in particular. So our work is mostly direct legal services. So folks contacting us and we see if we can help them directly with a legal issue or technical assistance. That can come in the form of helping folks navigate a USDA appeal or prevent foreclosure. We also provide services like estate planning, which can be helpful in, minimizing some of the challenges of heir property. We do bankruptcy work and we do work on farm business planning and other issues that are related basically to land tenure. So that can be land ownership or simply access to land. So things like farm leases. And I think Annette's going to talk a little bit about land and the relationship to land and what that can mean for people.
Hey y'all. Thank you so much for everybody being here and doing the work that you do. The community linkage for farmers, connecting folks to resources is so important for years and years and years, but even more so now. And our work is really centered around the power of land ownership, and that land access is foundational to being able to build community resiliency. And we see it as more than just the value of a piece of property. It really is very based in family, in community, in history, allowing people to connect to each other, to the land and to their family sometimes, especially when it comes to looking at the ownership of heir property, which is often rooted in the initial purchase of property, maybe generations ago, and family members that want to come together and see how they can keep it. Bear with me. Technical issues. And as y'all know, land ownership, whether it's a single owner or multiple family members that own land together, is a challenge. There are pressures that people face, whether that comes from development pressure, from increasing land values, access to land. How do you make a business work on the land? Farming, conservation, all of those things all come together. But when you have multiple owners for a piece of property that are created over time, there's a further kind of potential for conflict because you have differing ideas about what do you want to see happen on the property, who's going to make decisions, how do you like access programs and loans sometimes, and all kinds of things that kind of put an additional barrier in front of family members that own land together. So I'm going to talk a little bit about the rates of farmland loss. Y'all probably know these statistics. Uh, we found this one in a ERS report from this past year, and I like it in some senses because it really does kind of show how farming has changed over the years. But I also think because of the scale, it doesn't really give you a sense of how much land we've lost. Um, and nationally, it's close to I think four, I can't see the side, but it has been nationally a loss between just a relatively short period of time between 2016 and 2024. Being that we're based in North Carolina, what we do is we tend to look at how much we've lost in North Carolina, and that's almost 1 million acres in 20 years. And that's pretty extraordinary. The American Farmland Trust estimates that we would be leading the country, maybe second in the country in terms of loss of farmland, if we continue on our current the current direction that we're going right now by 2040. And we've just, continually losing farmland and the access to that land becomes even more difficult as you're competing with residential development and kind of sprawl in that peri-urban space, which is not unique to North Carolina. And so we just kind of look at this in general as a progress, as we call it land tenure, is just trying to figure out what are the landowners faced with as they look toward the future and how they can retain what they actually have.
Okay, and we wanted to talk a little bit about some of the legal foundations of real property and how it's owned. So, understanding title. And by title, that really just basically means ownership. Having title or holding title means you have a right of ownership. And oftentimes we're talking about title in terms of do you have evidence of your title? Do you have something that demonstrates or shows your ownership? Uh, the most easy way to demonstrate your ownership is basically with a written document called a deed. Um, that's the most, basic, straightforward document that has, usually a grantor giving property or transferring property to a grantee. And then the grantee can hold up this paper and say, I have title to this property. This deed shows it. Deeds are filed in county offices that are either the Register of Deeds or the Recorder of Deeds. And one great thing that's happened over the last few decades is that most of these registers of deeds, these county offices, make their records available online. So that can be useful when you're working with a landowner or farmer, and you need to kind of help them understand what their ownership situation is, what their title situation is. We have on this slide some different ways of holding title. This is the kind of thing that you might um, spend time on in your, first year real property class in law school. The one that's most relevant today for heir property is tenancy in common or being a tenant in common. So it's a form of ownership where multiple people have what's called an undivided interest in the property and in the land, meaning that though each person might have their own percentage ownership or fractional ownership, they still have rights to use and occupy the whole thing. Um, so what that, just as an example, if one person owns, let's say, a 3% undivided interest in 100 acres, that doesn't mean that they own 3 acres. It means they own 3% of 100 acres, and they have the right to access and use the entire property. Um, and I mean, that setup is one that we'll be talking through some of the difficulties of. How can multiple folks have full rights of ownership and possession of property? And what are some of the ways that we deal with that? So again, oftentimes in terms of documentation of ownership, documentation of title, the starting point is going to be a deed. Um, and you can look it up usually online. Other ways, other areas or that you might look to for documentation of ownership would be estate files or probate files if one was opened. So if a landowner had a will, there might be, it might have been probated, there might be an estate file showing who they gave their property to in their will. In some states, that process will result in a deed. In some states, you might just have to actually look at the estate file to see um, who the heir was.
The really interesting thing about this particular deed is that when you are dealing with heir property, is you might end up finding a deed that looks like this. So if you're working with a landowner that says, well, this is the last deed we have recorded for our property, you might see something that's handwritten and is quite old. Because that is kind of one of the tricky parts of land ownership where there hasn't been a formal recorded transfer. It's been passed through the family, is that you get older documents and with boundaries that are a little bit tricky to describe. So if you kind of read through the cursive writing here, if you can see it, what you'll see is a property description that is marked by physical markers. So they're describing here a corner on a rocky branch, and then it goes to a maple tree, and then there's a cedar stake, and there's a rock. And these are all descriptive kind of boundary markers that may have made sense 100 years ago, that may not be present anymore. So that is one of the things that we'll run into when we're trying to trace title, is looking at old descriptions that may not match the current ownership and use of the property. So, sorry.
No, thank you. That's great. Um, one other aspect of, often having the original deed be older and handwritten is really part of the history that um, land ownership among Black farmers is thought to have increased after emancipation and peaked somewhere around the 1920s and at about 16 to 19 million acres. So oftentimes, if you are working with a farmer or landowner who has inherited land as heir property, what you're really getting a glimpse into is the acquisition of land against all odds during that time period, maybe 100 years ago, and probably, 3 or 4 generations ago. All right. Just to make sure we kind of give um, a basic definition of heir property. I mean, the term is generally just used to refer to joint land ownership that has resulted when land has been passed down through generations um, without a will, and has resulted in co-ownership by multiple members of the same family. Sometimes it happens with a will. So a landowner might have given their property to all, 8 of their children, and then those children might have also given property to multiple of their children. But most often, we're talking about a situation where perhaps because of lack of access to attorneys or justifiable mistrust of attorneys, weren't necessarily wills written. And so over time, ownership interests have become shared among more and more people in smaller and smaller proportions. Uh, let's see. So sometimes we try to get a sense of how much heir property there is, and it's a difficult thing to do. There's some researchers at Auburn University who, used technology to kind of comb through property tax records to try to find words that indicated that certain tracts of land are owned as heir property. So property being listed to the heirs of someone. And of course, that might miss some tracts because sometimes there's just one member of a family who lists the property in their name. But that being said, it's a pretty significant amount of land in terms of actual parcels of heir property. So almost 500,000 estimated across the Southeast from this 2019 study. Um, I think the next slide shows some of the breakdown in the Southeast. Um, so these properties, you know, in the study that these researchers did add up to over 5 million acres, having a value of over $40 billion, which matters, in a few different ways. It matters first and foremost for the folks who own that property. It also can set up a situation where folks outside of the family might try to, take advantage of some of the legal difficulties of owning our property to get a hold of some of that wealth. And, again, we're in North Carolina, and that region has air property for some of the reasons we've mentioned. There are other areas of the country that have air property for their own reasons, right? Um, there's a good amount of what they call air-locked land in rural Maine. There's air property in New Mexico that kind of comes from a history of community land grants there. There's, a significant portion in Appalachia among white and black landowners there. But just wanted to give you a sense of, the breadth of this in the Southeast. Um, so, as we mentioned, the legal term for ownership of air property is property that's owned as tenancy in common, meaning that each person who owns property this way has an undivided interest in the property. So each person has the right to use and enjoy the entire property, even if they have a very small percentage or proportional interest. Each person has the right to transfer their interest to anyone they want. So that could be one of the other heirs, or it could be to a person or entity outside the family. Heirs cannot exclude their fellow co-tenants from the property, and each heir should be paying their fair share of the property taxes and paying their share of the maintenance of the property. We're getting here into kind of some ideal situations. I think it's pretty common among air property situations that we see that the things like tax payments are not typically always shared equally among family members. There might be someone who has taken it upon themselves to bear more of that burden. Um, but it's still, you know, legally the case that sharing the taxes is the way that it's supposed to go. And there are some legal vulnerabilities that can come up if that's not done. So, at least in North Carolina, there are ways that one family member can, seek contribution from other family members if they've been paying more than their share of the taxes. But in an ideal situation, all owners would be paying their share. Um, any any heir owner is again responsible for basic repair and upkeep. Uh, and in terms of major decisions about the property, uh, things like deciding to rent it out to a farmer or enter into an agreement with the timber company, ideally, these kinds of agreements should be made by all of the heirs. And if there is rent or profit coming in from something like a farm lease or a timber contract, that is also supposed to be shared among the heirs or put towards things like maintenance and upkeep and taxes.
So what you're hearing Mary kind of describe are some of the challenges that you'll find with ownership or shared ownership of property, and some of the major areas of conflict. When you're talking about land that was acquired 50 years ago, there's a difficulty in trying to figure out who are the actual owners at this time, especially if the family didn't stay in and around where the property is located. If people have moved out of state, if they have kind of distanced themselves, either physically or geographically. And one thing to note, we keep saying that we are, based in North Carolina, that it is based in state law. So how the land ownership passes down is going to be dependent on what your state says. And in terms of what ownership rights they have, what right they have for contribution, whether or not people can pay taxes and acquire title. In North Carolina, you cannot just pay the taxes and end up with full ownership of the property. But other states have, options where you can pay off a tax lien. And so that's one of those things that becomes very important to know kind of how it works in your state. Um, so, the kind of list that we have on the right is kind of some of the challenges that you'll find that are common. And some of those challenges, like what Mary mentioned with collecting rent, distributing proceeds from the sale of timber, paying taxes. Those are one of the highest areas of conflict that we find, especially when it comes to historical kind of conflict, because someone's family member, their grandmother may have been the manager of the property. And so there's kind of an assumption, well, you're going to take care of the property, or nobody else can take care of the property. So it kind of flips between kind of what becomes an expectation, and then kind of how people navigate that in their own families. We also see challenges that are unique to heir property owners when it comes to taxes, mortgages, and the partition. So those are uniquely kind of unique situations that are specific to heir owners that have a high likelihood that it can lead to dispossession of the property. So if a person is listed with the county tax office as the person who is the named party for the property and they get the tax bill, but they don't pay it or they don't update who should be getting that tax bill, the taxes can become delinquent. And then once you get to a certain point, the county and municipality can bring a foreclosure against the property. And usually, by the time you get the foreclosure filed, the attorney's fees that are connected to that foreclosure are as much, sometimes more, depending, than the taxes themselves. Um, and so they're immediately due, and the tax office may not accept payment plans at that time. So it's really important for the family to kind of know who's listed on the property, to see if the taxes are up to date and make sure they don't become delinquent. Mary mentioned earlier the option of partition. That is where any co-owner, at least in North Carolina, can bring a partition, which is asking the court to step in and either physically divide or sell the property and distribute the proceeds. But by the time you get to the court process of partition, the family members that own the property really lose their ability to control that process. So, then the court will appoint a commissioner that will decide, they'll get a surveyor to decide how that land is divided up. And then that is really not up to the family to decide. And then the costs that are associated with that, whether it's attorney's fees or the cost of commissioners, the cost of a survey, those are all that supposed to be divided between all the co-owners, and that it can be a very costly part of that process, with attorney's fees being $5,000 or $10,000, paying for a realtor to market the property. It is really an unexpected expense that I think some people maybe would want to do something differently if they kind of realized what that entailed. Sometimes a partition though is like your last option. So we're not saying that a partition is always a bad or unnecessary thing. But we do find that a lot of times people don't feel like they have any defense to a partition, and so they just say, okay. That's another state difference, how a partition process works. Um, there are multiple states across the country, about 26, I think, that have enacted a law that kind of changes the partition process from what it used to be. It's called the Uniform Partition of Heirs Property Act, which is designed to build in some protection for those co-owners in that partition process. So what we wanted to do, it is just kind of give you an idea of one of the first things that we look at when we're talking to a family about how they own their land is that we ask for a family tree. And this is a relatively straightforward example because you see there's one single owner with three children, and then two of those children had children. And so that I think would be almost uniformly straightforward if we asked kind of you see this family tree and you see who's passed away and who's left, and you can kind of get a good sense of who might be the current owners of the property. And so in the example, the green circles, they're still living. So you would find that there may be two in that upper line and then some children in that one that's on the right side that might share ownership in the property. But really, typically, what we get is an example that looks more like this. Right. So we have a family tree that becomes more complex. And I don't really want to go into the actual detail of the family tree as much to say um, that it is important to go back and find the original purchaser of the property, who their children were, and then who their grandchildren were. And then you look for deeds to see if any of those folks have conveyed their interest or if they left a will. And that's where our practice gets a little mathy. And I didn't go to school because I wanted to do math. But this is like a really interesting process to kind of go through with a family to kind of look at their, they talk with their family members, they talk with the elders, they look at who is related, and it really is kind of a journey of discovery. And it also kind of it becomes very personal because what you're talking about is kind of the family stories. You're talking about that history and that legacy, but you're also talking about things that are very personal to families, and will be unique to each family because rights change if people had a will, if there were divorces, if there were if one of the original owners or children died, but they had a spouse, there's a possibility that some of that land ownership could have passed outside the family. There's also in North Carolina specifically, where you still have kind of rules around legitimation, which means that if the parents weren't married, they may not inherit from their father. And so if that changes, so when we go into kind of examples of how to resolve property, that's kind of where we focus is like, okay, so we know the ownership looks like this, but what can you do with it at this point? And so the family tree is always our first starting point and one that takes the longest, and is the most personal to everyone involved. So I think we wanted to do some examples of kind of what we think and what y'all might think, kind of what you see. And so I'm wondering if this might be a good point to see if we have any questions before we go to examples. We've been kind of talking for a few minutes.
We don't have any questions in the chat right now, but I had a question. And maybe folks will be able to come off mute if they have questions. But I I was curious on the family tree. So if one of the children of the landowner marries someone, does that spouse then become a landowner in that family tree?
They can. Um, Sorry, Mary, if you were about to say something. I think it will depend on kind of the timing of things. So if you're, let me go backwards and see if I can go back to the family tree. Um, so in our example here, you have A, and then A had three children, B1, B2, and B3. If you were looking just at that line and one like B passed away, with B one and a half, B one and a half would share interest with their children, with C1, C2, C3, right? So if we were just looking at that in isolation, with none of them having passed away except for like the original landowner and then their child, their spouse could get an interest. So ideally, B1 would have a will. So this is only written this way. This is example is only based on them not having a will. But if they did not have a will, then their spouse and children would share that ownership. And so if B1.5 decided to write a will and give her interest or his interest to their sister or their, cousin, they could do that. And that interest would then go outside the family. If they passed away without having children, then it would just, so it really becomes it depends kind of scenario. So there is that possibility. Yes.
Thank you.
Yeah, and I think that it's sometimes families we're working with might say, yes, we've identified the original owner and each of their descendants. And we are often asking folks to also include in their family tree spouses, um, whether folks have passed away, um, dates of death, whether people had wills, if the family knows that. Um, And it is, I think, one of the more surprising scenarios sometimes for people, at least under North Carolina law. And I think it's this way generally. If you die without a will and you have a spouse and children, some of your interest is going to go to the spouse. And so, what if your spouse then remarries and has more children, or remarries someone who already has children? It can get more complicated than it might seem on its face.
That sounds very complicated.
Yeah,
Yeah,
and that's why it takes a while, as Annette said, that there's back and forth. There's a need to find pretty complete information.
I think that's one of the reasons that it's so important not to rush the process, and to really spend that time developing relationship with the person and the family that you're talking with, because they are very personal conversations. About someone may come to you and say, "Well, I know all the owners of the property, and it's these six people over here," because that is how they understand it. But it's important to do a little bit of conversation, because you may find out, well, yeah, well, I didn't include that line over there because they've never lived in North Carolina. Or, my grandmother told me that my father's line was supposed to hold the property. So we're the only owners, right? And it really does kind of involve conversation, and kind of it is a very delicate thing. I think, especially when you're telling someone that the way they've always kind of navigated something may not match the legal ownership. But there are ways to kind of incorporate that as you go forward. It's just kind of, we have to know where we're at now so your family can decide how to move forward.
That's helpful. Thank you. Does anyone else have questions before we move on? Okay.
Yeah, and it's all going to rely on the state statute about intestate succession. And yeah, you can look those up for fun in your state, to know what the rules are depending who's surviving when a landowner passes away. So we want to move on to some scenarios that are pretty, common and not too complicated, and what the first steps are. So let's say a landowner age 75 comes to you and says, I have family land and I want to resolve it because my parents weren't able to do so. So the question would be, what are the first steps? And, rather than necessarily putting folks on the spot, I think we'll just share what we think of as some of the early parts of the conversation. Because again, as Annette said, these are these are often going to be relationships that are built over time in terms of um, sharing family information and getting kind of an understanding of what the family situation is and what their goals are. So I think, one of the first things that we would recommend in this situation is that you go ahead and use the county resources to look up ownership information. So you can find out who the original owner was, and you can usually use their name to do a search on a county website. If you have the address of the property, you could also go to the property tax website and put in the address, and that might direct you to a deed. It might give you the book and page number of the deed of the original owner. Another question that it would be good to ask is whether anyone is living on the land or just generally to begin to gather information about the use of the land. And then it's also part of the conversation to ask if the family has a family tree starting with the original landowner, right? And that's where some of these issues about making sure it's complete with information like spouses and whether folks have passed away and whether they had wills. You might not get that far in, of course, an initial conversation, but you can start to ask questions about whether folks have put together a family tree and gauge the extent of the family's knowledge, basically. And then finally, you can ask if the family has had any conversations about the land and what their goals are, what their shared history is with the property. And you can ask about whether there are upcoming opportunities the family has to have those conversations if they haven't already, like a family reunion. Um, I think that again, these are kind of initial conversation starting points, and it's important, I think, not to necessarily start with an end point. Like, you know, I would like to become the sole owner of this property, for example. You're usually, in a situation like that, you would walk back to some of these first questions. Um, There are, by definition, if it's heir property, if it's property that's passed down in the family, there's going to be, multiple stakeholders, multiple folks who may have different perspectives, and it's important, I think, to kind of establish a information sharing and a respect for the family and their process as well.
So we have a second example where we have a farmer that is farming on land owned by as heir property, but they really want to see what else they're eligible for, or they want to change their production. And they say, "Well, my father was the manager of the property." Excuse me. So we kind of have to question. We have to ask some questions at that point. So we would first ask, how did he become the manager? Was that actually a formal agreement? Mary, I think you may have to do this.
All right, I, I can take this one.
Sorry.
Um, yeah, so you would just want to ask some further questions about what that means, right? What does it mean that your father was the manager? Was there an agreement um, among the family? Was that in writing? And then again, it's often helpful to find the most recent recorded deed. So you would ask who the original owner was, um, and try to find that recorded deed, but also check to see if there's anything more recent. And then you would ask whether other family members are engaged with decision making for the property or if they want to be. It's important to, take account of whether the family is on the same page about who is meant to be managing the land, who wants to manage the land, and whether there are other areas of current disagreement or prior areas of family disagreement. In general, you know, it's recommended to have agreements in writing. Um, but at this stage, you're basically in an information gathering stance.
I think there's a couple of other kind of areas here where you talk about a manager. That kind of option can really come from a couple of different places. So there's a historic kind of use of a document called a power of attorney, where someone may have acted on behalf of one of the landowners or the original landowner as the power of attorney. That document tends to disappear on the death of that person, though. And so it doesn't hold legal kind of, there's no legal authority after the person passes away, but sometimes families continue to honor that, and that person kind of stands in that position over time. They could have been named the manager because they were the executor of a will. And so then they just kind of carried out the wishes that were written in the will and then continued kind of exercising authority over the land, sometimes with the acceptance of the other owners. But it's not kind of like it also would end when the estate was closed. So those things may not be like legally binding, but they are in the relationship, the relational kind of gathering of the family, they are binding, right? So that's another area where you really have to kind of ask more questions. There's also people that are appointed or listed with the USDA. So they may be listed with FSA as the person, the farmer, the primary producer. And so that's another area where you may have to update those documents to get any kind of production history from the USDA is to say, well, this person is not in our documents. So you have to like prove their ownership so you can then go and get information with the USDA.
So the next scenario is Martha's dad has recently passed away. She says he owned the farmland and home and that he had a farm loan or mortgage. Martha currently lives in the home. So, what are some of the first steps and first questions we would ask her? Um, if someone has recently passed away, I think an early question is just simply, did your father have a will? If he did have a will, of course, you're going to, have questions about what it said and whether it's, um, been, whether an estate file has been opened. And it's good to encourage that. The second, if there isn't a will, you could ask who are the other family members that might have inherited an interest in this property. So, did the father have a living spouse? Did the father have other children? And now, in this situation, we are talking about a property that has a mortgage against it. So, when a landowner who's a mortgage holder passes away, that is a time when, you know, there's a risk of loss of the property, right? Because there's grieving, there's normal processes that don't involve everyone opening all the mail necessarily, um, or necessarily thinking first about financial matters. But it is, in the long-term benefit of the family to at the same time pay a certain amount of attention to the financial side, right? So you could ask when the last payment was made and whether the loan is current. There's protections in federal law for residences, and if you continue making a home mortgage payment, even though you're not the original borrower, that's always going to be the best thing, right? If the loan is current, the lender is probably going to be happy. But it's just an important thing to ask about to be sure that there isn't a delinquency in payments that leads to a loss of the property. Um, and then another question would just be whether Martha or the other family members have the ability to continue to make payments. I think whatever the answers are that you get from Martha, it's always good practice to go ahead and verify with record searches that the ownership of the property and the mortgage are as the person described, right? So you should be able to find both the deed and, it's done differently in different states, but a deed of trust or mortgage that's recorded um, so that you can verify, okay, yes, it was in her father's name, as opposed to, oh, it was actually in her father and brother's name, things like that. So it's good to look in public records to verify um, the ownership situation and the loan situation.
And these are really specific to traditional mortgages. I think if you're in a situation with a reverse mortgage, it would be different. So, these are some of the common misunderstandings that you may be familiar with. We hear them quite a bit, and we I don't think there's anything bad about them. I just think this is what we hear a lot. And so here's I just want to go through them. Y'all can jump in if you have others that you have heard. We would love to hear them. I'm the only one living here, and I have always maintained the land, so I'm the only owner, right? I've only been paying the taxes. I'm the only one that pays. Um, my mother paid before me, so we are the owners of the property, or we have the rights to make decisions for the property. We're going to rent it out, and then sometimes that money gets shared. Um, it was my grandfather's property, so my in-law does not have a right. They don't become an owner. Um, we hear a lot stories of families that pass the interest down, that they say, my mother wanted me to manage the land. She told me she wanted me to keep the land, and so therefore I'm the only owner. And while there are situations where you can have kind of oral transfers of property, like an oral will, they are very rare, and they have very specific requirements for them to be valid. And so most of the time, I'm not sure that that would be kind of what would qualify as that kind of will. But it's something to ask. It's something to ask about. And on the other side of that, some folks forget about their ownership in property, and say that they don't need to write a will themselves because they're only a part owner of property. And so then you have another layer of fractionation of that ownership interest that will happen if someone either forgets or does not include that interest in their own will. And then the last one would be all of my parents' children are legal owners, right? And that's the one that we kind of mentioned earlier with the legitimacy. And if the parents were not married, it might be that they're not. And so these are just things that we hear quite a bit. And sometimes we have to kind of review those records to see if they are correct.
Okay, so we wanted to run through, a couple more scenarios now that we've sort of looked at some of the misunderstandings. And maybe folks can either give a thumbs up or down or make their little icon do a thumbs up or a thumbs down on what you think about this one. So, a farmer comes to you and says that their mother passed away without a will, but told them to manage the land. Is the farmer the only owner? And as lawyers, we're always going to say it depends, but you can do a thumbs up or thumbs down for probably yes or probably no. Okay, and so if you said probably no, that's what we're thinking here, right? Um, Generally speaking, wills need to be in writing. There are sometimes in certain states exceptions for kind of deathbed statements if they are observed by witnesses, but that varies state to state. In general, if the owner has passed away without a will, you're not going to be the only owner unless there was no spouse and no other children. So I'm seeing the thumbs down, and that's what I would expect here too. And so the questions you're going to follow up with are just what the rest of the family looks like in terms of did the mother have a spouse? Did the mother have other children? And in terms of being able to verbally say you're the manager or not, that's also not something that is going to be established by just saying it. All right, so the next one, um, Annette already covered pretty well, so you can do thumbs up or thumbs down for this one too. So a landowner says they are the owner because they are the only one that pays the taxes. So this would be in an heir property situation where you know that there's more than one descendant of the original owner. Right. So paying the taxes in and of itself does not make you the only owner of property. It means you've done something nice for your family and made sure there isn't a tax foreclosure, but it does not, in general, increase your ownership share by itself.
So I think I probably spoiled this one as well. One of the heir owners is going to farm the land, but their auntie had power of attorney for the grandmother who was the original owner, and the auntie says, "Nope, you can't farm." So can auntie do that? What do y'all think? I can't see the voting. So I'm going to assume that you're all correct. The auntie does not have power anymore. When grandmother passed on, if auntie was her power of attorney, that power of attorney really goes away. Now, the current heirs can sign a new power of attorney document or a tenant in common agreement where they appoint auntie as the person to manage the land. If it's a document like that, I would say yes, she has authority to tell the person, no, you can't farm the land. But if it's rooted in a power of attorney that the grandmother signed, then I would say no, auntie doesn't have control anymore and the heir can farm the land. Because if you remember from our original discussion or earlier discussion, equal rights for the property. That means any one heir can use the whole property. Now, if they make money, like if they rent it out, to a hunt club or they cut all the trees off the property, they're supposed to share the proceeds for that property. But when it comes to profits and maintenance costs, they're all supposed to be shared fairly and divided fairly, based on the ownership interest. So it becomes a little bit complicated, um, especially they would not be able to share in heir owners' profits from farming, right? But they could say that, heirs should pay rent, on the land. I don't think they're required to pay rent because they're a co-owner, at least in North Carolina. But it does become an area of like potential conflict, because right away you see a battle of authority, right, with an elder in the family that's saying they are a decision maker with someone that may want to do something different. And so that immediately is something that I would say we would want to use kind of our mediation resources to kind of bring everyone to the table to decide together, if possible, how the land should be utilized. So this kind of leads us into paths toward resolution of the property. Like, what do you do with it once you figure out what you have? What steps do you need to take? And it kind of goes from a range of the less formal to the more formal. So the kind of less formal agreements that don't require a transfer of ownership would be utilizing an affidavit of heirship that just kind of lists out who the owners are at this time, how they got their title, a tenant in common agreement, which is where it's kind of like a contract where you would list out the current owners, what's going to be done on the property, who is appointed to kind of speak on behalf of those owners. And then you kind of have that as an agreement between yourselves. And then a power of attorney, a general power of attorney would also list out the owners of the property and the person they appoint to be that kind of face in the world. That document, though, would be filed in the Register of Deeds office, because it relates to land. It would have to be filed, and then anybody that goes through to look for the title history of this particular piece of property would see it there, that, oh, we need to go talk to Mary Henderson when we're looking at this particular piece of property, because all these folks that are on this document have identified her as the power of attorney for this parcel of land. Ways that do convey legal ownership would be agreeing to a voluntary division of the property. So going back to Mary's example of the 100 acres where you have a 3% interest, you can divide that up so people get land equivalent to their interest. That will require that you get a new survey, that, creates parcels for all the folks that are going to retain their interest. And you can kind of work with the family members to say, well, okay, this person doesn't want their land anymore. Their interest is going to go to cousin. Family lines can convey, keep their interest in one pool and maybe get a larger part of the property. So it really goes back to the importance of those conversations and deciding together as a family. If you have family members that you don't know where they are, so a family line that maybe moved out of state in the 50s and nobody knows where they are anymore, you can use a quiet title action or a partition to kind of resolve and clarify legal ownership of the property. And that will kind of create the pool of legal owners at the time. And then you can take that to divide the land or to own it together, however the family sees fit. But that does require going to court, and having kind of a court determine ownership. There are ways, if you know all the family members, you can form an LLC or a trust. That will consolidate the ownership of property because at that point, all of those co-owners will then convey their legal ownership in the property into the ownership of the LLC. So if we have 30 family members that say we all own this 100 acres together, rather than breaking it up into tiny pieces, we want to keep the 100 acres together because then we can do a forestry management plan, we can farm it, we have more resources if we keep the land as 100 acres as opposed to three. And so they all convey their ownership into the LLC, and then they decide together how to manage the land. And we create LLCs with an operating agreement that really defines membership. It will lay out how family members make decisions, what their voting process looks like. And we see it as a democratic way if you have a lot of family members that want to stay involved with the property. Trust functions similarly, except that will be for a situation or a family that maybe has a couple of people that want to manage the land, but other people that don't. So in a trust, you have the land held by the trust, again, that requiring a deed of the ownership being transferred into the trust, but a named trustee that kind of makes those decisions. They're kind of that point person. And then everyone else can be a beneficiary. So they can still access the land, they can receive profits from use of the land, but there's one single owner and one decision maker. We find that works for people that maybe want to hold their interest but don't want to be actively engaged in it. And both of those entities have different considerations, both tax-wise, eligibility-wise for programs. So it's definitely kind of a longer process to think about. And then we always kind of encourage that no matter what of those routes you take, that you include your heir property in your own succession plan, whether it's the farm business succession planning or your own personal estate planning. So sorry. Typically what you'll see in like a textbook approach to resolving heir property ownership is a focus on consolidating title, because that is the easiest thing for bankers to understand, for traditional kind of land tenure. There's a big focus on we need a single owner. And so you would want to consolidate the ownership and with a goal of it being non-adversarial. So retaining land and kind of the family continuity, the relationship in the family, and then really engaging people. But as we've mentioned already, it is a slow process. And, we always seek to avoid partition as the quick result, just because we've seen people lose so much in those processes. So generally what you do here is you first identify your the owners. As lawyers, it's really important. Um, we have ethical standards in terms of who is the client and who has the say so. So it's difficult to kind of represent the entire family. And so that is kind of an area where we're saying here there is a trade-off between the simplicity of having one client and developing really strong relationship and trust between the family. And so it's really important for clients to the lawyer to be clear about who their client is, and whether or not they can represent everyone. Um, you need to look for that last deed. I think we keep saying this. It may be the thing we repeat the most. One thing that we find with those deeds and kind of why we use that example of that handwritten deed, is that boundaries are sometimes a tricky issue. If you have a deed that looks like that with handwritten, a description that also mentions trees and rocks and streams, you may need a new survey. because the surveying techniques that are being used now are a little bit different. And your deed will typically say, 60 acres more or less. And when you have more modern surveying practices, sometimes we find that it's less, which is another kind of centering issue where you have to really kind of look at how much land is there. Do we need to reorient our understanding of what that is? Has there been some land that's been lost? Do you have access to the land from the road? Easements and right-of-ways are a real issue when you have ownership of land that was originally started in 80 years ago, especially if the family hasn't been there, living there for a while. Identifying owners, who they are, what do you need to do, and then picking the entity for how they want to hold the land in the future and kind of what role of engagement they want to have in that. And then you keep on this ongoing work of relationship really does not change. Um, if you form an entity like a trust or an LLC, they still need to have meetings going forward. So that original process where when you're identifying that family, those owners, creating that like communication between those owners, it continues into the future. So however that process works for them, whether it's a once a year meeting as a family reunion on the property to connect, or as monthly meetings on Zoom. That will continue into the future.
Okay, we wanted to bring up a couple of practical considerations about this process. I mean, Annette gave a really, in-depth and thorough overview of the steps for um, assisting landowners who are dealing with their property to, gather information and consider what direction they might want to take and the professionals they might need to involve. But one of the big practical considerations, as we've mentioned, is the amount to which it's really going to rely on the family's knowledge. And we've talked about the family's knowledge of their family tree, and the other piece that, we is also sometimes time consuming and relies on family knowledge is gathering actually the location and contact information for family members, right? Because if there's going to be discussion about, okay, do we want to consolidate title into an LLC? You have to both identify who the owners are as well as contacting them. So I think it's just, useful to consider that if you had to put together a complete family tree and include things like spouses and descendants and whether anyone has passed away, could you do that starting with your grandparents, on both sides of your family? Could you do that starting with your great grandparents, right? And if you even could make that family tree, would you then have a way to contact everyone who's there in your family tree? And I think this just helps remind us again that this is a time-intensive, fact-intensive process. So going back and forth with owners about their gathering the information, it is normal, right? To say, okay, here's what we have. Here's a branch that, we might need to gather some more information on, or, so and so is a cousin who has kept in touch with this branch, and so she might reach out and she tried an email address, but it bounced back. So it's a step-by-step process. In terms of other practical considerations, anytime that we are dealing with fairly sensitive topics like land and legacy and family, there's definitely potential for conflicts. In fact, it's normal. It would be really unusual for there not to be any kind of conflict. Um, so as as direct service providers, as folks that are, you know, there to assist the family, assist the landowner, assist the farmer, um, I think it can be really useful to be a third party who can provide some neutral information, right? Like, well, I know that if someone passes away without a will, then state law um, sets out how their ownership passes, right? And it can be useful to be a voice that can provide that kind of information. Um, I think it's important, to always be sensitive that land and family legacy are very personal, and also that folks who are in family together have a long history together. And as a outsider, you're not going to know as much about that. But it's important to be aware that you need to be respectful and um, not assume, and listen carefully, and assume, but you can assume that these issues are important and sensitive to the family. It's good to be upfront with folks that heir property resolution, things like building the family tree takes time. Something we've touched on a little bit is that mediation can be a really useful tool for, again, the very normal conflict that can happen in heir property ownership situations. Coming up, we're going to have some slides with organizations that provide mediation and similar kinds of services. Um, but it's, again, I would just want to normalize it that um, talking it out and coming from different points of view does not mean that it's time to stop, but in fact might mean that it's time to keep talking. Um, in terms of, the advocate or direct service provider yourself, it's important to provide clarity about your role. It depends on your background and your organization and your goals, whether you're actually there to um, assist in one way or in another way. You might be there trying to help a farm operator qualify for a USDA program, and that might be make your role different than someone who's just um, help interested in trying to help resolve an ownership situation by helping the family connect with a mediator or a surveyor or an attorney who can help them consolidate their heir property. So just trying to be clear about what your role is will always be, appreciated. So, if you think back to early in the presentation, we kind of tried to give a sense of the scope of heir property and how much of it there is. And that's why we appreciate efforts in recent years by USDA and FEMA and some other organizations where there have at least been some steps towards meeting heir property owners where they are. Um, recognizing that just because you own property as heirs doesn't mean that you should automatically not qualify because you can't hold up your deed. Um, so, for example, in the last Farm Bill, there's advancement made where farm operators on heir property are eligible to obtain a farm number. And there's kind of an array of documentation that USDA will accept, like a tenant in common agreement, and that can include self-certification, like an affidavit of heirship. And I would encourage folks to, you know, be assertive with, um, you know, agencies you are dealing with, that if they have an arbitrary restriction that requires something like a deed, I think it's important to question why, and see if there's other indicators of ownership that the agency could accept. in order to qualify for a program, right? If you are dispersing emergency funds to folks who have been affected by a disaster, for example, um, I think as service providers and advocates, we can kind of make the best case we can to agencies on behalf of folks who might be heir property owners that, well, here is how this person is an owner. Here are the tax bills that, you know, have been in the name of this person's parent, and here's how we can show their ownership. I would just encourage, trying to continue to move that forward in terms of making sure that programs are accessible to heir property owners, even if they haven't consolidated their title yet.
Yeah, thank you for that. And we just wanted to kind of highlight some of the work that's been happening across the state, or sorry, across the region, across the nation for heir owners. It's just tremendous amounts of work, especially over the most recent years, with folks offering direct legal assistance. I'm sorry, we did not list everyone here. We can't, and that's a good thing, right? That there are options for folks at no cost for them to be able to determine what their ownership are, to protect that ownership, that land tenure, that community investment at no cost to them. And so we wanted to just kind of highlight some of those groups, some of the work that's being done. Certainly, having a list of more of those free resources and would be great. So we can kind of compile them all. And then there's other kinds of assistance that are going on, technical assistance, mediation, that um, are also happening, so that not only are we looking at, conserving and preserving legal ownership of the property, but ways that folks can make money on the property. Because, if you can't bring in income, you're not going to be able to pay the taxes at a very minimum. So these folks really focus on kind of opening doors for families that own land together in various ways, whether that's agricultural or forestry. We have some really great examples here in North Carolina with the Black Family Land Trust, Sustainable Forestry and Land Retention Project, really working hand in hand with owners. Rafi is doing a lot of this work. And so we just want to see those owners be able to fully use and access their property and be able to retain it and pass it on to the next generation. Center for Heirs Property in South Carolina is doing this technical service provision as well as the direct legal assistance. And then we have like our universities that really stepped in. We've had historic researchers, researchers that have done historic research. I cannot speak. With Connor Bailey and Robert Zbawa, out of Auburn University, and Kara Woods, and it's just really Ryan Thompson, Thomas Mitchell. We're just doing incredible work, and then universities are really doing a lot of outreach now too, as Southern Rural Development Center, A&T, North Carolina State, really going out into the community and kind of talking about what does it mean to have heir property? How do you determine ownership? What can you do on the land? Vermont Law School has like the home for the Heir Property Practitioners Network, which is like a network of attorneys across the country that are really working on heir property ownership and how to protect that ownership. So there are resources out there for folks that are trying to keep and understand how much land they have. And we just want to make sure that as many people access that as they can, so that we can keep the land community, in the family, and for the best for all of us, honestly. I think that's it. That's like too long already, and we're right up on time. Y'all, I would really, really rather this have been more of a conversation. I think we're going to get a chance to do that um, over maybe in January. Maybe Mary, you can kind of Mary Alex and I, and maybe you can kind of tell us what we will do next.
Yeah, I think we are hoping to continue this conversation and maybe do some case studies um, around air property in potentially in January. Um, and we can definitely share more information. We'll be working more with Annette and Mary um, and I think we're hoping to work with lots of different folks generally to like create more case studies and interactive like learning experiences for the network generally. So more to come in 2026 on all the like case study and sort of practical learning opportunities. Um, I did just um, there was one note. I don't know if Deidre, if this was a question, but she said, I would like and appreciate access to the attorney network or info and how to connect. Annette or Mary, if you wanted to, I know if folks have to leave, I totally understand. One, there's a feedback survey link in the chat. If you have a couple minutes to complete that, but I don't know if you have time for like two quick questions that ended up being in the chat really quick.
I think that depends on whether you're an attorney as well. I think they do open membership to attorneys. If you're looking for how to connect with an attorney in your state, we would be happy to kind of connect you with the leadership of that network. So if you want to send us an email, I think our emails were up on the slide. We can try and connect you. Um, for either of those.
Thank you. And then the other question was, do the universities provide support nationally?
That's a good question. I don't know the answer to that. I think that the folks that I'm thinking of that are doing work are doing it in their state. And regionally, there is a grant where some of these practitioners are gathered with Sarah. It was funded a couple of years ago. So I think they are doing some of that. I feel like it will be kind of local to their state or region. So I think it will depend on which university, um, maybe.
Okay. And we'll definitely make sure that everybody has access to the slides, and that you all have, uh, you'll be able to get Annette and Mary's contact information, Mary Henderson's contact information from the slides. It's always interesting having two Marys in the room. Uh, yeah, I don't want to take up too much of people's time. Thank you so much for joining us today. We really appreciate it. And thank you so much, Annette and Mary, for really doing a thorough job and walking through. And it does seem very complicated, and I'm happy to have people like y'all that are working on this. Definitely might be reaching out myself about some questions. So thanks so much for everything that you're doing.
Well, thank you so much for having us and for the work that everyone is doing. I think even if we're not in your state, we're happy to try and connect folks with resources where we can. And we're kind of in here with you, doing work to keep people on the land. So
Thank you. I'll see
Thank
y'all
you.
later. Oh, sorry, Mary, were you going to say something?
No, thank you so much. Thanks for having us.